capacity to contract. It is strict law that any party that must enter into a contract must have contractual capacity. So because it is someone that is having a contractual capacity that can be liable, okay, under the contract. So a party to a contract must have capacity. So that means that the person must not be insane, must not be an infant, he must be capable. So somebody that is in a position to enter into a contract. So because where someone enter into a contract, it should be liable on that contract or under the contract, and also it should also be capable to enforce the contract. And so that is why capacity is necessary. One who does not have contractual capacity may escape liability under a contract. So we also want to talk about people that are having limited or no contractual capacity. So let us look at infant. An infant, according to Infant Relief Act of 1874, put an infant as someone below the age of 21. Below the age of 21. And the infant, based on general rule, does not have contractual capacity. That means that if an infant enters into a contract, enter into a contract with an adult, so the contract is binding on the adult, but is not binding on the infant. That means that the adult is liable, infant is not liable. The infant can escape liability under the contract, except where the matter comes up that the court may come up that the court must decide whether to enforce a contract or not. If as at that moment the infant should now raise an issue that as at the time he was entering into the contract with an adult, he was an infant, the court will not enforce the contract on him. Okay, so but if it has to do with the adult, court will enforce the contract on the adult but cannot enforce it on the infant. And so that is why infants does not have contractual capacity, except, so we have an exception, where the contract is a supply, is based on supply of necessaries. So necessaries are things that an infant will need, okay, in something that is so needful, okay, for an infant, and also is also needful as at the time such necessary are supplied. So that is what we call necessary. So where necessaries are supplied to an infant, then that means that the infant must pay for that very necessary. Take for example, we have issue of clothes, we have issue of food. Where an infant is hungry and order for food, infant must pay for that food. But this food must be supplied as at the time the infant is in need of that food. We have the case of Nash versus Inman. Where an undergraduate of Cambridge University ordered for waistclothes from his tailor, and the tailor supplied the waistcoat, but the infant refused to pay, and the tailor now sued the infant to court. But the infant contended that as at the time the tailor supplied the waistcoat, he was already having enough waistcoat, and because of that the court ruled that the contract was not enforceable on the infant. So that means that the court refused to order the infant to pay, because as at the time the waistcoat was supplied, the infant was already having enough supply of waistcoat. So where it is a necessary, the infant must be supplied the necessary as at the time the infant is in need of the necessary. So where that happen, such contract will be the infant will be liable under such contract. That means that the court will have to order the infant to pay for such supply. And also, an infant is having let me put it this way, maybe partial or limited contractual capacity to enter into a contract of apprenticeship. Limited contractual capacity. We have a contract of apprenticeship. And also contract of marriage. So where an infant enters into a contract of marriage, it is enforceable on him. So the contract will be enforced on him. Or contract of apprenticeship, because all these contracts are contracts that will be beneficial to the infant. So if an infant enter into such contract, so is liable under the contract. So is having partial or full or limited contractual capacity under contract of apprenticeship and contract of marriage. But as regard the issue of contract for the supply of necessary, infant is having full contractual capacity and it will be held liable. But any other thing that is not necessary, like the supply of car or any other thing so expensive that one cannot categorize it under necessary, or something very necessary for the infant's life as at the time of the supply, then the infant will not be liable under such contract, either to pay for it or to do any other thing under the contract. But where it has to do with necessary, infant is fully liable. Also, we have the case of a drunk and insane person. An insane person does not have contractual capacity except either drunk or insane, a period we call lucid period. If a drunk person or insane enter into a contract in a lucid period, that is the period where a drunk person may be said to comprehend what he is doing, either insane or drunk person, then that insane or drunk person will be liable. But where a drunk or insane person enter into a contract during the time of insanity or during the time or period of drunkenness, then such drunk person or insane person will not have contractual capacity. That means that if the other party should take the drunk or insane person to court to enforce a contract, and the insane or drunk person now contended in the court as at the time he was entering into the contract he was drunk or insane, the court will not enforce the contract on him, except if it is proved that the contract was entered into during the lucid period or as at the time the drunk or insane person is aware of what he was doing. Then we have corporation. Corporation can or we only have contractual capacity after registration or after incorporation. So after registration, a company we have what we call capacity to contract. And we have another one known as illiterate. So illiterate is having contractual capacity, okay, but is based on a condition. Illiterate must sign a contract under a jurat. So that means that a document will be prepared where an illiterate person is signing a document. He is entering into a contract and is signing a document. He must sign a jurat to show that the content of the agreement has been read to his hearing in the language he understands, and he signed it. Okay, so not under duress. Then that is what we mean by signing a jurat. And if that happens, the contract will be enforced on the illiterate. So the illiterate is having contractual capacity where the content of the contract is read to him in the language he understands. So that has to do with illiterate. Let us look at terms of a contract and exclusion or exclusionary clause or exemption clause. Let us first look at some terms. So when we are talking about terms or exclusion clause, we are talking about terms in a contract, that is statement in a contract or in a document of a contract that spell out right and responsibility or obligation of parties. Let us examine these terms. Number one, condition. A condition is a stipulation in a contract that goes to the root of a contract. A condition is a fundamental term. Then it goes to the root of a contract. Very important. And where there is a breach of condition, the innocent or the aggrieved party is entitled or allowed to sue for damages and rescission. Damages or rescission or repudiation. So damages has to do with payment of damages or is monetary, and also repudiation. Repudiation or rescission has to do with putting the parties into the position they were before the contract was made. So a condition is so important, very, very important. It's an important stipulation or terms in a contract. So any party that is in breach will be sued for damages and also for rescission to cancel the contract. Very important. And let me give you a case of Posa versus Spear and Pond. Versus and Spears and Ponds, where an actress, this is the case where an actress was engaged to play the leading part in a French opera, okay, as from the beginning to its end. That means that is to start the work and also to end it. And because he suddenly fell sick, she was unable to take up her role until a week after the season has started. So the producer, who has been forced to engage a substitute, then refused her service. So it was held by the court that her promise to perform as from the first, as from the beginning, amount to a condition. And because of that, that was a breach of contract. So that is what we mean by a condition. That means that the fundamental time has been breached. So that means that the person who engaged to involve in such opera was unable to start with them. And so because of that, he was unable to perform his major role in that very contract. And so because of that, the owner, the organizer, sought for a substitute. And because of that, the court held that because of the failure to end, that was a breach of a condition. Now let us look at warranty. Warranty is of a lesser time in a contract. So it is a lesser term in a contract. So a warranty only supports condition. A condition. So and the breach of it will allow an innocent party to sue for damages only. So for damages only, for disappointing the aggrieved party. And warranty occur where a particular term of a contract has been breached. But sometimes it used to happen where the party at fault is able to perform its role or is able to supply what is supposed to supply, but we still have some terms in a contract that he is unable to meet up with. So that will be a breach of warranty. So where somebody promised to supply a thing, a particular goods, Mr. A, for example, promised to supply a particular goods to someone else at a particular time. So if at the end of the day he is able to supply the goods, but who is unable to supply the goods at the right time, but the fact is that the other party who is to receive the goods is still able to make use of the goods, so that is a breach of warranty. Or take for example, he may promise to supply the goods at a seller may promise to supply goods to the or at the buyer's workplace or office or shop, and then maybe something happen and is unable to take the goods to the buyer's workshop, so or office, and then he may decide to call the buyer to come and take the goods from his own store. So it's a breach of warranty. If the buyer is still able to come and pick the goods, it's a breach of warranty because the buyer still get possession of the goods, but it's only that he is the one coming to the seller's shop to get it. So he can then sue the seller for damages. That means that for the inconvenience that must have been cause. So that, but he cannot cancel the contract. That is, he cannot say that he want to get his money back, to cancel the contract, to return the parties to the position they were before the contract is entered or was entered into. So this is what we call breach of warranty. That's why sometimes somebody may buy a product, maybe TV set, and there will be a breach condition of warranty on it, maybe warranty of 1 year, or maybe 6 months or 2 years. It means that if anything should happen to the product before the expiration of that very period, the buyer is expected to take the product to where he has bought the product, and the product, another one can be given to him, or even the product may be repaired, but that they should refund his money back to him. That will not happen because it is a breach of warranty and not a breach of condition. But if it is a breach of condition, contract will terminate, money will be refunded, parties will be returned to the position they were before the contract was entered into. Let us look at express time. Express time, where terms in a contract are stated expressly either by word of mouth or in oral form. It is called an express term. So it is written, or it may also be in oral form. Or in oral form. So that is what we call express term.